Further hearing.
Continuing from the stage where it was yesterday, one of the questions that would arise is, having regard to the array of parties and having regard to the finality of seniority list up to the year 2012, to what extent the present writ petitions were maintainable? And having regard to the pleadings regarding in support of the prayer sought in the writ petition. Prayer sought in the writ petition, I will point out, were twofold. To set aside annexure N seniority list, that is dated, that is at page 548, that is dated 16/3/2022. And the grounds raised in support thereof. Was there non-joinder of necessary parties? Because ultimately, my lords, in the matter of seniority, everybody above the petitioner in the seniority list need not be made a party. But at the same time, everybody whose ranking you are relying upon as wrong to get the relief you want, they have to be made a party. There is a fine subtle distinction. Suppose I am challenging a select list, either a promotion list or direct recruitment select list or appointment. Everybody in the select list has to be made a party, because there the consequence will be of setting aside the select list or order of appointment or order of promotion would be they will lose their office, or element of Article 21 also would be involved there. Therefore, everybody in the senior, in the ranking, in the select list, whose appointment I am challenging or whose promotion is I am challenging, they have to be made parties. But in the matter of seniority, a slightly different view has been taken by the Supreme Court, saying that persons against whom you are claiming seniority, they should be made parties, at least in representative capacity. Now I will point out, from the pleadings, they wanted almost from serial number 33 in the seniority list, they attacked the ranking of every one of them, naming them by serial number assigned to them in the seniority list. But persons whose ranking was attacked were not made parties to a large extent. Now, if my lords would kindly take the volume 1, that is the writ appeal papers, volume 1, writ petition is at page 142. You may not should kindly see the array of parties. Respondents 4 to 12. They were either deleted or no case was pressed against them. Because what I find from the order of the learned single judge, which is at page 44 in that volume, is discussion about the illegality commences from respondents 13 to 47. That is, if my lords would kindly turn to para 3 at page 64. At page 66, this is how it starts. Thereafter, the government by notification dated 26/3/2015 passed the final seniority list promoting the respondents 13 to 17 as district judges from the cadre of senior civil judges with effect from 1/4/2015. There is no discussion in the order between as about 4 to 12. I think they were given up or something has happened which they will have to clarify. Now, if we, one thing is, effectively respondent 13 and down, beyond that, it was their seniority that was questioned. Serial number respondent 13 is AK Naveen Kumari. Her ranking, if my lords would take the final seniority list that was challenged, annexure N at page 548. The ranking of Naveen Kumari is 288 at page 567.
Page
67.
Why 67?
Did you give up or what?
288.
Regular list they are shown above us.
After this,
They are pushed down below us.
Yaru.
Therefore, we find below that as far as they are no grievance.
Anyhow, no case was pressed against them.
Already passed
That they are continued in the array, but there was no attack against their appointment. What I am submitting is
they are deleted.
they are deleted,
There is an order granted.
but unfortunately their name continued to appear in the cause list. Amended cause list was not filed or something must have happened. A last minute amendment one.
Being spoken to what is that? In that order taken. And is the last
to
course of the order.
who has spoken? No, why is he senior?
Yes.
First and produce argument.
Yes, yes.
ಇಲ್ಲಿ ಬಂದಿಲ್ಲ ಇಲ್ಲ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್.
Yes.
Yeah.
Either a correction copy. At page 233, at page 233, there is an order. 4 to 12 are deleted.
Now these 4 to 12 were belonging to which category?
4 to 12. What category they have not mentioned in the
All
pleading.
these respondents are promotees.
Therefore effectively,
Not LDC, no?
Is
the
LCD
first contesting respondent is A.K. Navina Kumari, who is at serial number 288 in the impugned seniority list. That is the point I would like the honorable court to take notice of. And now, if a look is taken at the pleadings in the writ petition, writ petition is at page 142, that is what they call it as amended writ petition. Straight away, my lords can come to the grounds in that writ petition. That is commencing at page 168. Para 5.6 at page 172. A perusal of the impugned final seniority list would reveal that 139 officers are said to have been accommodated, adjusted in respect to the post as a result of increase in cadre strength. That is, officers at serial number 38, 47, 57, 59 to 67, 73, 78, 80, 87, 87, then my lords, up to, then they come up to 274 in the third line, 276 to 281, 287 to 89 and all that. Their challenge to placement starts from serial number 38. But they they do not make any person a party from serial number 38 to 280. 38 to 280. In the seniority list, that is at page 548. It includes FTC judges, fast track court judges who are assigned seniority. Then departmental competitive examination persons from 99 at page 552, 100, 101, 103, 104, 105, then some direct recruits 106 to 112, then departmental competitive examination persons from 113 to 117, 118, 120, 122, 124, then one entire page, 555, 127 to 139, 140 to 153 in the next page. All of them are competitive departmental examination.
158.
158, 159, none of them are made parties. Even if I take stream wise, you are challenging the placement of FTC judges, perhaps contending that they have been granted seniority from the date of their ad hoc appointment, not made a party. Another category of persons whom we are saying are wrongly included are the departmental competitive examination category. None of them are made a party.
No, none of them.
Not one of them. Ultimately, who are made parties? The point I am making is twofold. Promotees promoted under promotion quota. Therefore, this writ petition, firstly, it suffers from non-joinder of necessary parties. At least each group.
I am sorry, this contention is not raised before the single judge before the division judge. How could he can raise no? Can he? In the vacuum, can he argue? If this kind of argument is around, where is the meaning? Where I have to answer? Is it, I have to answer in vacuum?
Let us see, let us see.
But kindly, these are the facts. These are all facts. What has to take notice before addressing the argument?
Let us see, we'll consider.
I object for this.
We'll see. When we'll,
Readings are not there.
let us see.
Readings are there, let him argue.
No, let us see, we'll consider.
But the question is, that is not raised in writing. Court has to say something, my lord. Otherwise, not where we have to go.
We'll consider. Yes,
I am not relying on my pleadings. If a ground is available to me on his pleadings, even without objections, I can raise it. Suppose I challenge an order passed by the employer, and certain grounds become available to me from out of the written statement filed by them. I need not amend my writ petition. Similarly, where I am a respondent, petitioner's pleadings itself, if it is going to damn the case of the petitioner, I need not file a written statement of objections. I can argue on his own pleadings. What I am pointing out, I am not relying upon the objections filed by the High Court. I am pointing out the pleadings in the writ petition. And whether necessary party is there before the court or not, it is the obligation is cast on the court also to see. For example, under Order Rule 10, nobody can be impleaded against the wish of the petitioner. But the court can dismiss the plaint if it comes to conclude necessary parties have not been made parties. It is as simple as that. One is absence of necessary parties. Second is, it is a biased writ petition in the sense you raise a dispute about fair placement of some persons from serial number 37 onwards, but you make party only from 280 onwards. And 280 onwards, we belong to a particular stream of recruitment. Therefore, what emerges is, it is a petition lacking in bona fides. You want to somehow steal a march over the heads of the promotees who entered the cadre earlier to you. Therefore, you are attacking them. And you know fully well that unless all the persons are displaced, you cannot still make a march over me. You mention all those facts, but you don't make them parties. It is a case of absence of bona fides in the pleadings that I am submitting. Whether such a writ petition would be entertained. That too under extraordinary writ jurisdiction, where truth and truth alone should prevail. And a case founded on deceit would not be entertained. That is one aspect of the maintainability. Second aspect is this, Manoj. I have placed down a record by way of a judge, and they have also pleaded on the basis of that judgment. That judgment is judgment of the earlier division bench in challenge to the immediately preceding seniority list. Now, kindly take in the writ petition that I am referring only, in their they mention about this particular judgment. That is the 2012 judgment, which is also referred to in the order of the learned single judge. That is in the if my lords would take page 44, where the order of the learned single judge starts, para 3 at page 64. It is the case of the petitioners that on 14/9/2012, the respondent 3 have published the final seniority list in the cadre of district judges, promoting the ad hoc district judges, fast track judges who were appointed during 2003 and regularized in 2009, and they were placed above district judges who were appointed during the year 2008. The said seniority list was challenged before this court in writ petition number so and so, and the said writ petition was allowed, whereby a direction was issued to refit the interstate seniority of directors and promotees in accordance with law. Being agreed by the same, respondent 3 herein had filed writ appeal. Respondent 3, the High Court. Writ appeal number so and so on connected matters, and division bench of this court by order dated 3/4/2014, ILR 2014, allowed the writ appeal and set aside, pursuant to the direction issued by the division bench by order dated 3/4/2004, in writ appeal number so and so and connected matters, the respondent 3 published provisional files and seniority list and in the cadre of district judges on 24/7/2014. Thereafter, government by notification dated 26/3/2015 passed the final seniority list. There is some error in the sentence. It must be independent. This one, promoting the respondents 13 to 47 are district judges from the cadre of civil judges with effect from 1/4/2015. What are the facts stated here? There was an earlier seniority list. It was challenged. It was set aside. Directions were issued. Thereafter, final seniority list was published. No challenge is raised to that seniority list. That has become final. And that seniority list was up to just prior to my promotion. That is, kindly take the division bench earlier judgment, the judgment in volume 3. Volume 3, the volume 3 of the judgments, not the papers. Where is the division bench judgment, the registrar judgment? Give it. There is a volume 2 of the judgments. At the earlier division bench judgment commences at page 304.
Hearings have to be here.
Para 4 of that judgment, my lords, 317. Para 4, I am pointing out only to say earlier seniority list was dated 14/9/2012. That was set aside. And kindly see what are the dicta laid down by the division bench in this judgment. That is, para 81 at page 412. This is about FTCs and departmental competitive examination candidates. The questions raised by the learned single judge could be answered in the following manner. That the extant procedure in the matter of promotion to the post of district judge was followed while appointing the promotees as ad hoc district judges for the FTCs. Their promotions are in substance traceable to 1983 rules. The vacancies that occurred prior to the enforcement of 2004 rules have to be reckoned for giving deemed effect date of promotions from the vacancies arose, but not from the date of their promotion on ad hoc judges, ad hoc basis in 2003 or 4, nor from 2009 when notifications were issued. That the district judges who were promoted in the notification dated 26/6/2009 to fill up 25% vacancies through departmental under 2004 rules would be entitled for the same benefit that could be extended to those who are appointed under 50% quota to be filled up by promotion on the basis of seniority cum merit, provided there were vacancies existing prior to 2004 rules and they possessed the requisite seniority to fill the post. The departmental competitive exam taken by those officers is relevant only for adjusting 25% of vacancies subsequent to 2004 rules to fill up the quota of 25% vacancies meant for accelerated promotion under the 2004 rules without disturbing their seniority in case there were vacancies to which they could have been appointed prior to 2004 rules. Therefore, promotion of ad hoc judges, district judges as FTC judges could be treated as regular promotions in the cadre of district judges under the 1983 rules and subsequently under 2004 rules from the date vacancy arose, but not from the date of issuance of notification in the year 2003-2004. The promotion should be adjusted in the quota mentioned in 2004 rules on the enforcement of those rules. The 2009 note are in substance regularization of those promotions. Therefore, seniority and promotions would have to be reckoned from the date they filled up the vacancy in the cadre of district judge and not from the date of their appointments as ad hoc judges. Even if promotions as ad hoc judges were in the absence of vacancies under the 1980, the appointment must be deemed to be made from the date vacancy. But if there were already existing vacancies prior to the date of issuance of notification, appointing it would be from the date of their notification. Then final directions are at page 84, para 84. Here, as far as the direct recruits are concerned, their seniority would be reckoned from the date they were appointed. Here it is not the case of the present petitioners that their seniority has been postponed beyond their date of appointment. In fact, Annexure N shows that all these direct recruits, even in the present batch, have been given seniority from the date they were appointed. That is, they entered the cadre in the year 2016 by direct recruitment, and they are there at page 573 from serial number 373 onwards. 373 to 380. 8 persons. Four of those 8 are the petitioners. Page 573. ಅದು seniority list 544 ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. 548 it starts.
ನೋಡ್ತಾ ಇದ್ದೀರಾ seniority list?
At page 573, their names are shown 370 to 380, and kindly take the remarks column. They explain how they have been placed at those places. The seniority of the officers at serial number 373 to 380 is fixed by reckoning their seniority from the date of their appointment as district judges. That is the best they can get, because no person, either a promotee or a direct recruit, can get seniority from a date earlier to their appointment. One exception is there in the case of promotees, that is where, suppose they had been promoted earlier on ad hoc basis and they were continuously discharging the functions of the district judges. By virtue of Rule 32 in case of civil services, and by virtue of the judgment of this court in the earlier round, suppose today I am promoted, 1 year ago I am promoted as ad hoc judge. After 1 year I am promoted on regular basis. In between, if the promotional vacancy has arisen, and if I have worked continuously at district judge from the date of my ad hoc appointment till today, I will get seniority from the date vacancy arose, regular vacancy arose in my stream, but it is not anterior to appointment as ad hoc judges. But insofar as direct recruits is concerned, there is no question of ad hoc appointment or continuous officiation. They can get only seniority from the date of their appointment, which has already been given. Where is the grievance? There can be a grievance if, in respect of each of them, each of the promotees, each of the FTC judges, each of the departmental competitive examination judges, if they are able to demonstrate, look, A has been given seniority from 1st of February 2024 or 2014. He was not eligible because there was no vacancy. That has to be shown in respect of everybody. And then, after adjusting according to the dates of the occurrence of vacancy, if somebody has to be pushed down beyond 1/2/2016, only against them they will get seniority. Now kindly see what is their pleadings. On the basis of the earlier judgment and seniority list pursuant thereto, which is not under question, at least up to 2012, that is the earlier date of the earlier seniority. Seniority had attained finality. Is a writ petition maintainable to review the earlier judgment without making beneficiaries of the earlier judgment parties? Now, there is a seniority list published in the year 2012. That was set aside with certain directions. Nobody who was a party in that writ petition came up saying that you have not either published a seniority list contrary in pursuance of the judgment, or you have published a seniority list which is contrary to that judgment, therefore I am entitled for a higher ranking. Here, an effort is made by referring to the ground that you have to rework the vacancies from 1983. By doing it, what is it in effect you are seeking? In effect, you are seeking review of the final seniority list prepared pursuant to the earlier judgment without challenging that seniority list. It is these things you cannot challenge by side wind. If somebody who was in the cadre in the year 2012 has been granted seniority contrary to the earlier division bench judgment, straight away he or she has to be made a party and said that your seniority is contrary to that judgment in which you are a party, without doing anything of that sort. By saying that from 1983 you have to redo, what you are in effect seeking is review of the seniority list which is not challenged and review of the judgment itself. No, my lords.
All these respondents, either they are promoted as district judges on 30th March 2015 or
Yes.
13/8/2015.
Yes.
If it is a contention of the writ petitioner that in excess of the quota, if these people are promoted as district judges, had they not been promoted, when they are appointed as direct judges, they would have been, they
Above
would have
us.
been above all that.
That is their.
Can they question it?
This is the question. But can you see the pleading? Serial number 37 onwards, you will have to push down. Where have you made them parties? Either individually or in representative capacity. No, prayer is different. What is the basis for that prayer? By clever drafting. On facts. Facts are held in what they have pleaded. I am not under any confusion. I am pointing out. Please see. Para 5.12. Para 5 is their grounds. I am reading para 5.6.
That is in volume 1.
Volume 1, page 172. Not at one place, but at two places. In the same paragraph. They want surgery to be conducted on the dates of. I don't know. I have the permission of the court to read it.
You should not misguide the court like that. Your statement is that I have made a statement that I must be placed above them. Let him show any sentence not regarding that. He cannot argue in error.
I am not saying that they should be. What he wants is
You must
they must be pushed down.
We are not for promoting of direct recruiting. If I made such statement, Lord, that I am claiming seniority over them or not, yes. Nowhere. I want the entire paragraph can read. I am only saying that 13 to 82 was promoted. We should be placed above them. Nothing else.
Now kindly see the ground.
Let him show one sentence that I am claiming seniority. I am only over 38. Anywhere I am claiming, no.
What I am saying is,
He cannot say something before his court and say I am claimed like that.
I am reading plain English.
You are plain English. You read please by this. Let the court know. The conduct of the appointment in this case.
Para 5.6. What it says is, these many people have been accommodated. And it starts from,
ಈ ಸ್ಟ್ಯಾಂಡ್ ಬಂತು.
then
ಅವಾಗ ಏನಾದ್ರು ನಾವು ಹೇಳ್ತೇವಂತ ಈ ಸ್ಟ್ಯಾಂಡ್ ಏನು these many people are
promoted.
place above them. In the carrier of never claim seniority.
And
Only giving example, these are the matter or only 30 to 85 excess. Because quota is different. These are the quota.
and they say that these are the promotions in excess of the quota.
Yes.
That means their appointments are in excess of the quota. If their appointments are in excess of the quota, what is the consequence? They will get eligibility dates beyond their dates of actual promotion. The question is, when you are saying the promotion of these persons at serial number so and so is beyond the quota, should they be heard or not? Is the short question. Otherwise,
if person agreed can tell.
Will come, let him finish, let him.
Proper facts should be changed before this court. We are claiming seniority over 38 and so and so. We have no problem. We will only claim seniority over 40 into 82. Respondent 40 into 82. That is the end of the paragraph. That is it. Nothing else. Paper 73. But what should be guided properly? Not the way. We are here to fix people. By saying wrong facts, not
each fact,
we not give anything.
I am reading what he has stated. If it means something different from what I am saying, court also is English knowing court will decipher. I am only reading what you have stated. I have not done anything else. You are castigating 3 classes as having been accommodated in excess of the quota. Should those classes be not represented?
Let us look at that specific pleading from this.
Yes. Increase in cadre strength, that is officers at 38, 47, 57, 59 to 67, etc., etc. 281, 287 to 289, 293 to 295, 297, 391. The set posts which result as increase in the cadre strength have to be earmarked as per the quota prescribed under the rules for it is to be mentioned that in the respect of some of the promotees, there is no mention of the date. However, even assuming that the cadre strength is increased by 139 posts, only 90 posts are available under 65%. These 114 are adjusted against vacancies. Again, those names are repeated. Now, the vacancies that have been classified among the 3 sources recruitment after making block periods coming from 83 rules. Thus, the respondents who were promoted in excess of cannot be given to them. Who was against
What it is, let the court know. Let him read the entire paragraph.
Even if you repeat 10 times, I will read the manner I will.
Mr. Bhagwat, let him finish.
This way argument is that is not what we can do.
No, you'll get your chance.
Not that court must know the facts. Wrong fact is not related to the court.
No, please don't do that. Now everybody have their own style of argument. We are not going to be swayed. We are going to independently look into. Let him finish. Let him finish. We'll come to you.
The fact remains, in this paragraph, 3 categories are referred. That is not denied, that cannot be denied. Ultimately, prayer is claiming seniority against the director promotees. I pointed out that only. It is a deceitful and a prayer lacking in bona fides. You say that accommodation of 3 different categories is wrong. At the same time, you claim seniority only against one category. What does it mean? If all the three categories have contributed to excess promotion, how can the relief lie against only one of those categories? And all the three are necessary to say whether and which stream has been granted excess more than their quota. Whether it is FTC judges who are governed by a separate clause in the earlier division bench order, where they said FTC judges you have to treat two different ways. One is if they are eligible before commencement of 2004 rules under the promotion quota, they have to be given that, ignoring the fact of their promotion first and thereafter regularization under the FTC and thereafter regular one. Second, departmental competitive examination.
So which date is 13 to 82 are promoted?
Yes, minutes.
Date 13.
Dates of 13, 18, I'll point out. Kindly see, 38 is promoted.
13 to
13 to 82.
when they are promoted.
Yes, minutes.
13 to 82.
All of you when you are
All of them, whose
13?
seniority they are questioning when they are promoted.
That is, they are promoted,
finally.
page 548, 26/5/2003 to 13 lilla seniority list. There is no, the 13 is not there. 38 onwards it is there in the seniority list. That is what is mentioned in paragraph 5.6. 38 is appointed on 26/5/2003 and 82 is promoted on 1/2/2006. Their seniority was questioned in the earlier round.
The respondents 13 to 8.
13 to 18 when they were
82.
promoted.
Respondents 13 to 18, we are promoted 31/3/2005 and that is
1/4/2015. 1/4.
there are two dates, that is
13 to 47, 1/4/2015, not
48 to 82 on 21/8/2015.
2 days. Not 2005. Kindly note it, 13 to 47 are promoted on 1/4/2015 and 42 to 82 are promoted on 21/8. Not 2005.
We are promoted in 2015, earlier to their appointment.
Yes, yes.
There are, what confusion is, in pleading he refers to the respondent. In serial number, in pleading while he refers, here he refers challenge to the 13 to 82. But however, in the pleading he refers to serial number of the promotion. So what is important is disputed
Only
is
that.
respond number. There one here. Respond number 13 to 82,
Yes, sir.
when they are promoted,
Right.
respondent.
Respondent 30/1/3 to 47,
Huh?
1/4/2015.
1/4.
2015.
Hmm.
Then what? 48 to 82,
Hmm.
21/8/2015.
Yes.
2 days. That's
Those-
all. That promotion prior to that.
Not dispute.
Those dates are not in dispute.
We are not disputing. We are not.
Their direct recruitment is in February 2016. We were promoted in April and August 2015, earlier to their entry. That is not in dispute. What I am saying is, the ground on which you are claiming relief against me is traced from serial number 38. And 38 to 280, because the first private respondent is at serial number 280. 38 to 280, you refer so many numbers as requiring to be surgically either chopped off or pushed down. From there, may not be below them, but from their present rankings in this earlier seniority list. Because all these vacancies arose on different dates. Even if somebody is, suppose a person has become a high court judge and retired, number of them have happened so. Suppose you want to push them down even by a few days, are they not necessary parties? You may ultimately say, no, I have not claimed any relief against them. That is different. But whether their appointment on a particular day, their deemed date on a particular day, was it valid or not, they alone can say. Not me.
The other question that will have to be dealt. Now, one is insofar as many of the promotions were earlier to their entry. That's one aspect. Now, if they were to contend that though the promotions were made earlier to our entry, however, if the proportion of that feeder is X and the number of promotees have exceeded that, at any point subsequently I can claim to challenge that. How to?
It cannot be at any point, because one principle in service jurisprudence that was settled way back in 1975 in P. Sadashivam, was what Lordship Justice Alagiri Swamy said as an unscrambled egg cannot be scrambled. Of course, that was a case of promotion. What the Supreme Court said was, if a person is aggrieved by anybody's promotion, he should approach the court in 6 months, maximum 6 months time. Otherwise, it will have a cascading effect and you will be seeking the court to unscramble a scrambled egg, which is not possible. And here one another aspect to be considered is, by 2012 judgment of this court, that is ILR 2013, seniority list up to 2012 has become final. Therefore, your grievance can be only in respect of a deemed date or actual date of eligibility assigned subsequent to the judgment of the division bench in 2012. You cannot go back in time to a date anterior to the division bench judgment. In division bench judgment, what was set aside was seniority list dated, that is
2012 seniority was set aside.
14/9/2012. It can be only promotions and appointments made after 14/9/2012 that can be the subject matter.
Does not mean that.
They are all promoted. All the
That's what I
respondents
do
are
of-
promoted.
We are all promoted in the year
In the
2015.
year 2015.
Yes.
So to decide
Not yet.
whether the promotions that are given in 2015, whether in excess of quota or it is sufficient, for that, why should we go to 2012?
That is because, see, that seniority list has become final.
No, even it might have, but as per the quota only, they are entitled for promotion.
They are entitled for promotion. They can question the allocation only in respect to the vacancies that has arisen after 2012. And not only that, replacement theory also will apply where it is quota based, post based. In a post based quota, what happens is a vacancy created by retirement or promotion of a promotee will have to be filled by promotion, because the quota is worked out on number of posts in the cadre. A vacancy caused by retirement or promotion or something happening to the direct recruit, it can only be filled by direct recruit. This is the theory of replacement, which this honorable court said way back in the year 1985. A division bench of this court has said where this replacement theory was that long anterior to R.K. Sabharwal. The question that arose before division bench of this court was, now there are two types of quotas. One is vacancy based, another post based. If it is a vacancy based quota, irrespective of how the vacancy arose, it has to be filled up by operating the quota. Quota gets precedence there. If it is a post based quota, since quota is linked to the post, a post vacated by a direct recruit has to be filled up by direct recruitment. My only one rider to that is up to 2004 commencement of the Rota 2004 rules. Since there was no definite quota for direct recruitment, that principle of direct recruit occupying a post vacated by a direct recruit would not arise in respect of posts that were in existence on 9/9/2005. But for subsequent accretion to the cadre strength, replacement theory will fully apply. Prior to 9/9/2005, since direct recruitment was not pursuant to any quota, but it was a discretion, permissiveness that was determined by the High Court, there the replacement theory would not apply. Therefore, for the purpose of applying the quota, what would happen is, if the seniority list as on 12/9/2012, after modification, if it has attained finality, reworking cannot go back earlier to that date. To that extent, the division bench, Lordship Justice Rice order, insofar as it goes back to determine the blue book. Up to serial number 25.
Just one minute.
Now, learned judge KK Rai avaru, Rajesh Rai, he goes on to review the posts from 2002 onwards, and of these, up to serial number 25,
That is what he is saying. It is only simple argument is, Snagratna in para 84 she has said, if it is a cutoff or something, when vacancy arose, that is a substantive date for seniority. We cannot separate which part one can do.
ಡಿಮಿನಿಮ್ಸ್ 25 ಆದ್ಮೇಲೆ ಕೊಡೋದಾಕಿರೋದು ಎರಡೇ ಪೋಸ್ಟ್ ಡಿಮಿನಿಮ್ಸ್ and ಡಿಮಿನಿಮ್ಸ್.
in fact has given a smartphone order for release but were not sought. Yes. To the extent that paper one private respondent is not credible, these would not credit on credible. So that is the argument. Then all this need not have been set aside. So it is an order which is
They could only have depended. The reasoning is something that required.
After it will also have to show in 2015 the promotions were made vis-a-vis the contention that we are raising. That there has been an excess. The factual part, apart from what you have adverted to, they will also have to make it.
Yes, they'll have to make notes because earlier round having appeared before the learned single judge, I appeared for the High Court. Before the division bench, I appeared for the promotees. At that point of time, promotions made up to 2012, representing the High Court, I had placed on record the notes submitted to the state government, because what happens is either ASIC Administrative Committee 1 or the full court, they decide about the promotions. Once those promotions are decided, that note regarding promotions placed before the committee or full court would indicate this is the cadre strength, this is the available posts for promotion, and then they say these people are eligible within that quota and they make the promotion. And while forwarding those papers to the state government, because ultimately the
Who's that to the High Court? In the 2015, the promotion, the administrative committee, the resolution, and that there will be a note. That perhaps would shed some light to enable us to appreciate it better. So that that when your turn comes once again, you have to place that.
in fact there is a when the promoters came with this, my first question was that note and letter to the government placed on record. Of course, they being private respondent, they were not aware. No, here, no, that's the point is September or November 2012 seniority list was challenged. It would have taken into consideration vacancies that were the number of posts existing as on that date. That is, up to serial number 25 in the vacancies matrix that was post matrix that was placed before the High Court. Up to serial number 25 are covered by the earlier seniority list. That cannot be reopened. It is barred by constructive res judicata. If that is so, what remains? Kindly take that memo placed by the High Court regarding the number of posts. After item number 25, Only 2 entries are found fault by the learned judge. That is item 33, item 34. Both of them are equal to 1 post. Kindly see. This is 33 and 34. They are of the year 2014. Last entry for that would have gone into the earlier seniority list is item 25. Because the seniority list that was challenged earlier was of 14/9/2012. That means it covers up to item 25. Now we are talking of seniority assigned to the persons appointed up to 1/2/2016, out of which our promotions are 1/4/2015 and 15/8/2015. Now, if this chart is taken, vacancy, this post matrix, 33 and 34 are the 2 entries. Next page, if my lords to take, 37, 38, 39 are the items found fault by the learned judge. They are all after my promotion. Therefore, they are not relevant to determine my seniority.
No, for argument's sake, assuming that as on, serial number 36, please come to serial number 36.
Yes.
What was the cadence strength as on that day?
As on that day, 307, even excluding what the learned
So
single.
let us not exclude it.
Yes, ma'am. 307.
307. So as per the rules in vogue, how much for the direct duties, how much for the.
That is what I have said in my the memo. That is
9/1/2006.
9/1/2026. Maybe with the difference of 1 or 2. What I am submitting is, kindly take para 7 of the memo. Page 7. Third line. Therefore, the cumulative quota of number of posts available for these streams as on 30th March 2015 would be 212 for promotees, 24 for direct recruits, and 13 for in-service LDCE. It is not the case period by the direct recruits or determined by RRKJ that promotees who have been granted seniority from the date of the order of promotion add up to more than 212. That is my say.
And how many were promoted?
It is not the question of promoted. How many promotees were in cadre on 31/3/2005, 2015?
As per this serial number 36, as on that day, the cadence strength is 307.
Yes. Total were within the cadre strength. Out of that, nobody has placed before this court. Promotees were more than 212. 212 was the quota available for promotees. It is not the case pleaded by the petitioners that on the day we were promoted effective from 1/4/2015, number of promotees in the cadre exceeded 212. There is no such pleading. I can be pushed down beyond the date of my promotion Only if the promotees occupying the cadre as on 1/4/2015 were more than 212. Maybe one or two this side or that side, because yesterday I found there is a quote difference of 7 in paragraph 5 or so in my computation. Sorry, I did the subtraction and addition long years ago. And this,
All these lawyers are not good at mathematics.
Whenever I am a student of physics and mathematics, I am ashamed to say that I have committed such stupid mistakes in subtraction. Ultimately, I take solace from the fact, if you ask Einstein 7 into 7, how many 7 sevens, he may say approximately 49 because he is too intelligent for that. Whereas a second standard boy will correctly say that it is 49. Now, what I am trying to submit is, up to entry item number 25, it has been gone into in the earlier judgment. That cannot be reopened. Then what remains before my promotion? It is only item 33 and 34. In a cadre strength of 258, 2 posts, it is, I would say, hit by doctrine of de minimis. Because even if 2 posts are taken, 25% of the quota, which will come to 0.5 for direct. That 0.5 needs to be, would have required an examination if even one direct recruit had been given a seniority after his date of actual appointment, but they have all been given on the date of actual appointment. Bulk of this excess determined by the learned judge is 8 posts as on 1/9/2015, which are at serial number 37, 38, 39 at page 4. All these are taken into cadre strength all these have been taken into cadre strength after our promotions. That is taken into cadre strength only on 1/9/2015. Therefore, if this principle of constructive res judicata and de minimis is applied, what would really affect our seniority, even if Lordship Justice Rice's view is assumed to be correct, will be 2 posts which would not alter our position. It will be barred by constructive res judicata and doctrine of de minimis. That is my submission on that. Now kindly see the other pleadings in the writ petition. My lords may kindly take page 174. Para 5.9. The impugned financing commences arbitrarily from 1/5/2003. The promotions affected after the said date alone are taken into consideration. However, the vacancy position prior to 2003 is not considered. Promotions granted in excess of the quota prescribed for promotion prior to 1/5/2003 are not accounted for. Such of those promotees who are promoted without there being any substantial vacancy within the quota earlier to the 2003 are first required to be adjusted against vacancies that arose after 2003. Thus, all the promotees in the final were to be pushed down after accommodating the persons who were promoted in excess of their quota. Kindly say all the promotees, not from any particular date. As a cascading effect, the respondents 13 to 12 to 82 who are promoted in excess of their quota are also liable to be pushed down. Now, can this be determined in the absence of all those persons, or at least representative capacity? Second is, where is the question of your going back prior to beyond anterior 2003 when to 2012 it has become final? One inference that could be drawn from para 5.9 is an implicit acceptance of the fact if promotions are made after 2003 are taken into account, we are not in excess. Kindly see the theme of that paragraph. Theme of that paragraph is if promotions made earlier to 2003 are taken into account, promotees are in excess of their quota, all of them will have to, who are in excess, will have to be pushed down. By cascading effect, 13 to 82 are also liable to be pushed down. Therefore, the foundation for the relief sought is alleged excess promotions made prior to 2003. In this light of this paragraph, can it be said that they are not necessary parties, at least in the representative? Can it be said that it is not amounting to reopening the earlier 2013 judgment of the division bench? Can it not be said that taken after 2003 we are within the quota? Paragraph 5.9 is an implicit admission that after 2003, if it is taken, promotees are not in excess of their quota. Then, Manoj, para 5.9. The provisional, see about the 8th line in that paragraph, 5.10. The commencing like this. The impugned final seniority list commences from serial number 38 relating to appointments made after 1/5/2003. Names of the officers from 1 to 37 are not shown. Though the provisionally commences was published for the period commencing 15/5/96, final seniority list is published from 1/5/2003, which is illegal. Though certain officers are promoted to the selection grade, their seniority of officers in the feeder cadre would always remain. The provisional list dated 24/7 contains the names of all persons, though some of them were even elevated as judges of the Honorable High Court. Thus, all promotees from serial number 38 onwards were to be pushed down after accommodating the persons who were promoted in excess of their quota from the date on which 83 rules came into force as a cascading effect as follows 13 to 80. Therefore, entire thing against me pleaded is I am the victim of a cascading effect. Original effect, original wrong, you cannot correct it now because of 2012 judgment. But cascading effect of that you corrected. It is like asking, foundation is false, but I am not asking foundation to be cut, but you cut the first floor. How can it be? Then, at paragraph 5.13, page 178, the impugned final seniority list is prepared without considering the directions of the Honorable Apex Court in paragraph 29 of All India Judges Association 2002-4 SCC and the principles laid down by Honorable Supreme Court in the case of Punjab and Haryana High Court versus State of Punjab. The admission is High Court of Punjab, that judgment would apply. And it is that judgment yesterday I relied on to point out how the quota has to be worked out. Quota before amendment, the posts existing before amendment have to be treated differently from the posts arising after amendment. That is what has been said there. Para 48, 49. That is paragraph 48 and 49. And first part of the attack is, it is contrary to the All India Judges Association judgment number 3. All India Judges Association 3. That is All India Judges 3.
Give the volumes.
Yes. Para 83, page 83.
Volume 1. Volume 1.
After that, all the judges case,
Yes, ma'am.
the direction is on.
Direction is para 29. What? That date is, date of the judgment, that is 21st March 2002. My lords, in December 2005, the rule has not been amended. No, para 29.
You registered your argument. You only felt that what is the direction of the apex court? You have been implemented. Sometimes doesn't look nice. Sorry.
My lords, I entirely agree.
Your point is
I entirely agree, but kindly see Article 235. Under Article 235 of the Constitution, control over subordinate judiciary and their service conditions vests in the High Court. Supreme Court, even in December 2005, has reiterated that position and said, what we are laying down is under Article 142. Primacy of the High Court is constitutional. Our direction is under Article 142. How would you reconcile this? Stricto sensu. Aside the case that I am arguing, can 142 be invoked to give a direction contrary to the Constitution? No. Supreme Court is aware of it. Therefore, it said, state government and the High Court concerned may make appropriate rules. That has been said even in the year 2025. Again saying, henceforth. When you use the word henceforth, all the so-called deviations up to December 25 are washed out.
There are two parts. One is your argument is very taken in the sense of the point that you made is though the Supreme Court had directed to subject to with the rider that the rules must be framed. And in the absence of rules being framed, we cannot fall back on that. That argument is very taken. But what we are saying is we read
Very important. When it says not, order will prevail. Order will prevail. Without tense.
It's all right.
Quite all.
Order will not overrule the contract.
We'll examine that.
Yeah, that can be examined.
But what we are saying is, once the direction was there, perhaps if the High Court had framed the rule, it would have reduced any
It would have increased the litigation because under the Rota rule, now they have interpreted in December 2025. It is worse than the Quota rule. And Rota rule will operate if unchecked so outrageously. To borrow the words of Supreme Court itself in an earlier judgment, it can be said, when promotees were in uniform, direct recruits were schoolians. They will march over this. Can that be allowed? How it will arrive? I will point out. Rota applies where quota has to be considered while filling up every post. Now suppose, take the case of present 50, 25, 25. That is 50% promotion, 20% LCDE, 25%, 25% DR. In a Rota, how it applies is, first two posts you should fill up by promoters. Third post you have to fill up by departmental competitive examination. Direct recruit by the fourth post. Now suppose what happens? For 2 years, 3 years, no direct recruitment takes place. What would happen? Those posts would have been held by the promotees. Now when after 2 years, 3 years, 4 years, when direct recruitment takes place, if you can severe fourth post, 4 years subsequent direct recruit will come and occupy. That is the malady in Rota. Whereas when there is only quota rule, what happens is, two promotees retire this year. Whether other streams have been operated or not, two promotees can be promoted. The difference between quota and Rota is this. Even under the quota rule, one stream cannot be sterilized on the ground that other streams have not been operated. That is the principle. Even if there is delay in direct recruitment or in departmental competitive entrance, as long as there are vacancies arising under the promotional quota can be filled up without waiting for the direct recruitment to take place. That is quota. If you bring in Rota there, what happens is you cannot fill up even that. Or you can fill up subject to the peril of the promotees to be pushed down below the direct recruits of subsequent years, even though the promotees are within their quota. Now kindly take one or two judgments which I have filed on this issue. That is, one judgment that could be relied on is throwing light on this Rota and quota is Volume 3 A.K. Subraman. How the quota works. It is 518. That's what I'm saying. 518. This is a case where there was no Rota, only Quota was there. Para 20 of the judgment at page 527. Alan, sterile. Synopsis. Para 20 is for the, all that it state is, even temporary posts go into the quota. There is a para 20. There, Bishan Sarup Gupta dealt with a situation where there is breakdown of quota rule. There is one sentence here, Malords, in A.K. Subramanian. Non-operation of one quota does not render the other quota sterile. That is what I am trying to locate. That is, para 23. At page 529. It is submitted by the respondents that one-third quota cannot be filled unless the two-third quota was exhausted. This, in our view, will introduce sterility in the quota rule so far as promotees are concerned. Their hopes and aspirations cannot be related to the availability or non-availability of direct quotes to fill the two-third quota. Each quota have to be worked out independently on its own force. One need not wait for the other. Posts within the promotional quota, they can be filled up without reference to the whenever direct recruitment is made. This is the essence of quota rule. Now, if you introduce the Rota, they will operate simultaneously. And there can be quota rule without a Rota. That is what is said by the Supreme Court in N.K. Chavan. Where is my synopsis? Synopsis is in N.K. Chavan. That is judgment number. That is judgment at page 195, volume 1, para 30. Here again, we are not disposed to hold, having special regard to the recent decisions of this court cited before us, that quota is so interlocked with Rota that where the former is expressly prescribed, the latter is impliedly inscribed. Let us logicize a little. A quota necessarily postulates more than one source of recruitment. But does it demand the manner in which each source is to be provided for after recruitment, especially in the matter of seniority? Cannot quota stand independent of Rota? You may fix the quota for each category, but that fixes the entry. Quota methodology may itself may take many forms: vacancy-wise ratio, cadre composition-wise proportion, period-wise or number-wise regulations. Myriad ways can be conceived of. Rotational or roster system is a commonly adopted and easily understood method of figuring out the placement of officers on entry. It is not the only mode in the code and cannot be read as an inevitable consequence. If that much is logical, then what is being done here is legal. Of course, Garg's criticism is that quota is not viable without provision for seniority, and if nothing more is found in the rule, quota itself must be understood to apply to each post and when it falls to be filled. If exigencies of administration demand quick posting in the vacancy and one source has gone dry for a while, then the proper course is to wait for a direct recruit and give him notional date of entry as of the quota vacancy and manage to keep the wheels of government moving through improvised promotions, expressly stripping such adhosists of rights flowing from temporary occupancy. We have already earlier dealt with the same submission in a slightly different forum and rejected it. Nothing more remains to be said. There can be only quota, there can be quota coupled with Rota. And in the even as on today, the rule in Karnataka is only quota and no Rota. The Supreme Court was made aware of this lacuna in the Rota system by the states which implemented the Rota system. Then it directed in the latest judgment, that is, 2025, 26, page 17. Sorry. We give the copies for the other side and also this. This is judgment rendered on 19/11/2025. They refer to all the earlier judgments. Para 29. Para 27 onwards, Para 25, it reads about the All India Judges Association, case number 3. Thereafter, in the All India Judges Association, Union of India, 3rd AIJA, this court specifically examined clarification sought by the case and found that 5 years of legal practice prescribed as a minimum qualification to the lower rank of judges to be perfectly in order, then aimed to establish, etc. Then 2010, then the para 27, they deal about the direction issued to adopt a 40-point roster as required in, settled in R.K. Sabharwal. The All India Judges Association, the requirement of minimum experience was dispensed with, finding fresh graduates also eligible to offer themselves for recruitment to the lower ranks of the judiciary, especially in the context of mandatory training period of 1 year having been provided. Further, a faster promotional opportunity was provided for judicial officers in the lower rank by prescribing LDCE. That is what is now referred to as All India Judges 3 in the 2002 judgment. It was also directed that for proportional representation of RP, LDCE, DRs, a ratio of 50-25-25 would be applied to the cadre of district judges. Seniority at the entry point in HJS being determined on a 40-point roster as approved by this court in R.K. Sabharwal. Then para 29. This ratio has however been once again modified this year itself in 2025 to 50-25-25, also revamping and expanding the framework for accelerated promotion from junior division to senior division and thereafter to HJS. As of date, the decision of this court in Rajesh KV has further enabled the service of judicial officers to be reckoned for the purpose of direct recruitment to the HJS through participation in the direct recruitment. Then para 30, the series of Ajja decisions thus acknowledges and recognizes the fact that in a democracy, the role of judiciary is truly indispensable for the efficient functioning of rule of law and to ensure that our democracy prospers. It is rigor that we nurture in efficient laws. High Court as repository of powers. From para 31 to 36, primacy of the High Court is reiterated with reference to Articles 233 to 235. At the same time, we are also cognizant of the wide-ranging powers and general superintendents vested with each High Court regarding the judicial services within their respective states, union territories. To understand the width of these powers, one need to not look beyond the decisions of two constitution benches of this court in B.S. Yadav and in Bal Mukund Shah. To explicate, B.S. Yadav was a case in which judicial officers promoted to the higher judicial service of Punjab and Haryana, two different states with a unified high court, challenged the determination of seniority, intercept, promotees and direct recruits based on two different sets of rules. A constitution bench of this court held that though the state legislature as governor has the authority to pass laws regulating the recruitment to the judicial officers in the state under Article 309, the extent of these powers is to be regulated by Article 235, ensuring that the rules and regulations made do not impinge on or detrimentally affect the control vested in the High Court. Similarly, in Bal Mukund Shah, this court considers the application of reservation of vacancies as enacted by the state of Bihar in the direct recruitment, both to the House higher judicial and the grassroots level. The Constitution bench therein held that appropriate legislature or the governor can regulate the recruitment and conditions of service of the persons appointed to public service and post only subject to other provisions of the Constitution, including power of superintendents conferred on the High Court. It is therefore quite clear that under Article 235, it is therefore quite clear that both the Constitution bench decisions definitively state that whether it concerns recruitment or the determination of seniority, the state legislature empowered under Article 309 or the governor exercises power to make rules under the Article 309 ought to consult the High Court. This is especially so when Article 309 is subject to other provisions of the Constitution, giving primacy to Articles 233 to 235, wherein the control of the entire district judiciary is conceded to the High Court. Having said that, we consider it necessary to observe that there can be no doubt that this court faces no constitutional impediment in exercising its unique power of judicial review under Article 32, read with other relevant provisions of the Constitution, Article 141 and 142, to lay down uniform guidelines. Kindly mark this word. What Supreme Court lays down is not law, it only uniform guidelines. Uniform guidelines governing the structure and function of judicial services across the country. It is imperative to note that this very function has been carried out by this court through a series of judgments passed in an instant writ petition, as well as in other cases including Rajneesh KV and Malik Mazhar Sultan, with the consistent goal of strengthening judiciary by fostering uniformity in the structure of judicial services, enabling judicial institutions to be more effective, and ensuring that excellence and merit continue to remain the hallmark of judicial officers. There is no gainsaying that Articles 233 to 235 assign policy decisions such as specific manner of implementing directions of this court to the domain of the High Court. At the same time, it is also essential that overarching guidelines which would apply across all states be framed to ensure the development of unified and robust judicial services with the ultimate goal of cultivating an independent judiciary. These guidelines do not foreclose the powers of the High Court Kindly mark this. These guidelines do not foreclose the powers of the High Court. Instead, they establish a homogeneous framework within which each High Court, as constitutional court, can exercise superintendence over judicial services. They admit unapologetically that power vests in the High Court. Then, as a postscript, they add what we say under 142 is a uniform guideline without impinging on the High Court's power to regulate and supervise. And kindly see the direction part of it, para 78. While this particular issue remains pending, there is one judgment has been referred to the Constitution bench, which is still pending. While this particular issue remains pending in the above mentioned reference, in our view, keeping in mind the most celebrated principle of assigning seniority on the basis of period of continuous service, while also acknowledging the almost inevitable incident of speed bumps, the model delineated hereinafter for the purposes of HJS would be most appropriate. It is a model and not a model law. And what is that model? Model is para 97, conclusion and directions. I'll take another 10 minutes, Malars. Yes, ma'am. Why there is only one assignment? Why 2002 judgment, no rule has been made pursuant thereto? It may be a subject for discussion in the full court. It may be a subject for discussion in the full court. But as on today, rule has to be implemented. Next step. 13th. 6th could be. Very much. 13th, I have no difficulty with number 13. I believe in Sarvasiddhi Trayodashi. Trayodashi avuttu. Sarvasiddhi Trayodashi anta ಹೇಳ್ತಾರೆ.